Hi, welcome to your fourth module of your IP course. This module is titled The Economics of Intellectual Property, Innovation and Creativity, and we'll be looking at the policy linkages between IP and innovation and creativity. I'll be mentioning which slide we're on as we're going through the lecture so that you can follow on the PPT as I discuss. The last 200 years have seen intellectual property take on a very significant role in how innovation across the world is gone about. Of course, intellectual property is not the only way in which innovation can happen, but it has taken on the central role in the especially the last 200 years or so. With the knowledge economy growing, the importance of rights over information, rights over who has information, what they can do with it, this plays an increasingly important role in how economic development and economic growth happens. It plays a significant role in how culture is spread. So, in some way or the other, intellectual property is almost always interfacing with our day to day lives and our day to day activities. When the first wave of scholars initially started studying intellectual property, they focused on it as drivers of economic activity rather than as mechanisms through which innovation can work. So, in a way, they focused on it as an end in itself. However, this gave way to the second wave of scholarship in intellectual property, and the second wave placed intellectual property in a wider economic context, in a wider social context, looking at it as one of several different activities that promote economic growth, that promote cultural growth, that promote technological growth. And by placing it in this larger context, they focused on how intellectual property interacts with all these different other activities which also affect and contribute to these various types of growth. In this module, we'll be looking at this economic analysis in this second wave of scholarship. Since we're looking at this from a policy perspective, we'll be focusing primarily on the normative analysis. That is, rather than focusing on what is right now, we'll be looking at what ought to be, the prescription of desirable consequences. Let's move on to the third slide, that is the economic analysis, part 2 in the readings. Now, there are four major schools of thought on IP. They are the natural rights or the Lockean theory, second, the personhood or the Kantian theory, third, the social welfare or the democratic theory, and finally, the utilitarian theory. Very briefly, though you probably will be studying or have studied this in other modules, the natural rights theory looks at rights as something a creator deserves. That is, if they contribute to something, they deserve to get something back from it, and hence they get intellectual property rights over such contribution. The person-here theory then looks at intellectual property as crucial to the satisfaction of fundamental human needs. That is, IP could be justified either by saying that expressed their will, that is, their personhood, through a certain type of activity, and hence, in order to protect that expression from appropriation or modification, they need intellectual property rights over such creation of theirs. This is one way that the personhood theory looks at it. The other way is that the contribution to society creates social and economic conditions which are conducive to creating intellectual activity, which is in turn important to human flourishing. Thus, this is the second way of justifying intellectual property. Then we have the utilitarian method. The utilitarian method is the most accepted or the most widely accepted version of the justification of IP. And the utilitarian method, very simply put, says that intellectual property rights should be shaped so as to maximize the net social welfare. We'll be discussing the utilitarian method in a little more detail a little later. And finally, we have the social welfare theory, which is very similar to the utilitarian theory, except it is willing to take a moral position. That is, it says that rather than just the maximum benefit for the maximum number of people, it specifies what a just and attractive culture is, which does not necessarily mean the maximum benefit for the maximum number of people. For a more detailed analysis on these theories, I would highly recommend reading William Fisher's Theories of Intellectual Property. I've referenced the citation in footnote 7 if you want to look it up. Now, the economic analysis of IP primarily concerns itself with the utilitarian justification. So, as I said before, the utilitarian theory justifies IP as mechanisms that can be used to maximize social utility or social welfare. Now, this is easy to understand as a broad principle. You want the maximum benefit for the maximum number of people. But translating this question into administratable terms is a little more complicated, since the utilitarian theory doesn't describe which people you want to benefit, or what does greatest good mean, or why should you look at a majoritarian outlook on welfare. So translating this into administratable terms requires us to answer two questions. First, how do we achieve greatest good for greatest number? That is the utilitarian ideal. In other words, how do we achieve maximum social welfare? And the second question is, when we figure out how to achieve this, how do we apply it specifically to intellectual property law? Now, for the first question, that is, how do we achieve maximum social welfare? The broad law and economics movement has given us two broad methods which can be used. Firstly is the Kaldor-Hicks criterion. This is a measure of economic efficiency which focuses on maximizing welfare by preferring outcomes where the party gaining from the shift from one scenario, that is the benefiting party, could either practically or even just theoretically compensate the party being made worse off, and even after such compensation still be better off. Since this compensation only needs to be theoretical and doesn't necessarily need to be practical, it could, therefore a more efficient outcome can in fact leave some people worse off. An example of a outcome that is approved by the Kaldor-Hicks criterion would be if factories and people around them come to agreement that the factory will continue to pollute after compensating the people. Therefore, even though it's continuing to pollute, it is making enough profits to compensate the people being harmed as well as continue polluting. This would be an outcome approved by the Kaldor-Hicks criterion. However, since under this method, the factories aren't actually required to compensate the people around them who are suffering the harms of pollution, even though they don't compensate the people, this would be considered an approved outcome under the Kaldor-Hicks criterion, just because even if they did compensate, they would still be able to continue. Now, looking at wealth maximization is a method of achieving welfare, of maximizing welfare by focusing on the use of wealth as a proxy measure for social welfare. That is, the wealth maximization system prefers outcomes which maximize welfare, and this welfare is measured by the consumer's ability and willingness to pay. So technically, wealth maximization does not fall under the utilitarian method, but is slightly different from it. However, several scholars have strongly contended that in any case, using the Kaldor-Hicks criterion as a method of maximizing social welfare, when this is converted into practice, into actual policy on the ground, this starts tending towards wealth maximization. Therefore, wealth maximization is also a policy method which can be looked into while discussing the law and economics approach. So now we have two methods through which we can achieve the maximum social welfare, that is, two policy approaches. There are, of course, other policy approaches which also can fall under the law and economics movement or the utilitarian movement, but these are the two big ones, and this is what we'll be focusing on for now. You can look up the other methods on your own separately if you wish. Now let's move to slide number 4. Now, to translate this maximum social welfare into exact or precise administratable terms has led to, again, three different approaches. I'll just briefly mention what they are before we discuss them in detail. Firstly, the incentive theory, which states that social welfare can be maximized by ensuring that efficiency gains made by incentivizing innovation through IP rights, or exclusionary rights as they're more technically appropriately called, are greater than the deadweight losses and other inefficiency costs incurred by allowing such restrictions in the first place. That is, the incentive theory looks at a cost-benefit approach, saying that efficiency gains from a greater rate of innovation has to be more than the efficiency losses which are caused by preventing free access to such innovations. Secondly, we have the property rights approach, which essentially states that property rights are the best determinants of patterns of productivity which are likely to enhance consumer welfare. And the third approach looks at IP rights as one of at least 2-3 other innovation mechanisms, and questions whether, or rather which method can be best used to reduce duplicative or uncoordinated research and innovation activity. That is, it looks to reduce duplicity of research. Now, before we look into what these different approaches are and how we can use them, we first have to understand the nature of information goods. Information goods are known as, in economic terms, as public goods. This is because they are non-rivalrous in nature and non-excludable in nature. So what do these terms mean? A rivalrous good is one which once used cannot be used again. You can think of rivalrousness in terms of consumption. Therefore, the opposite of a rivalrous good, that is, a non-rivalrous good, in contrast, is never extinguished regardless of how many times it is used. For an example, an apple is a rivalrous good. This is because once someone eats it, no one else is able to eat or consume that apple anymore. In contrast, information or information goods are usually non-rivalrous. That is, for instance, an information good such as a book, the book can be read by someone and then someone else can read it again. The book does not get diminished by the more number of people reading it. Therefore, it is a non-rivalrous good. A perfectly non-rivalrous good, such as pure information rather than an information good, is one which can be used an infinite number of times without any loss to the information. That is, regardless of the amount of consumption of the good, the marginal cost of providing it to another consumer is always zero. Similarly, an excludable good is one whose use can be restricted to only a certain number or only a certain set of people. It can be differentiated from rivalrousness by thinking of excludability as the ability to keep someone out from using it. So though they sometimes overlap, a good way of understanding the difference in your mind is that a rivalrous good is one which gets diminished with more consumption, while an excludable good is one which does not allow more than a certain number of parties to use it at the same time. So a good example of an excludable good is the light from a lighthouse. Since it provides light and hence directions to any and all ships that pass by, it is only restricted by the extent to which the distance that light can travel, and therefore it's almost completely non-excludable. Similarly, private parks or even public parks, roads, they're mostly non-excludable unless there is a separate entry fee or toll tax, which lends it a more excludable nature. Let's move on to slide 6 for some examples to help better understand what excludable, non-excludable, rival and non-rival means. So if a good is both excludable as well as rival, then it has the nature of a private good. Therefore, an apple, as previously explained, and most day-to-day items around you that you see, they tend to be private goods. So clothes, food, flowers, they're excludable as well as rival. They're excludable because only one person can be using it at one time, and they're rival because when someone consumes them once, this reduces the ability for another party to use them again. Of course, clothes can be used secondhand, so in this example, consider clothes as maybe not such a rival good. It may be placed a little wrong in this graph actually. Next, we look to the block to the right, that is when a good is non-excludable but rival. These are known as common goods, also known as common pool resources, since the typical examples of common goods are natural resources. Since it is non-excludable but rival, this means they tend to be overconsumed or abused easily. Since they're non-excludable but still rival, they're very easily overconsumed or even abused. With no excludability, it is in the rational interest of individuals to consume and gather as much of the good for themselves, as the rivalry factor means that there will be less for them if they do not consume it. This phenomenon gives rise to the term tragedy of the commons, which refers to the problem of depleting limited resources of common goods. Next, we have goods which are excludable but non-rival. These type of goods are commonly made artificially scarce, since it requires a certain membership in order to enjoy the benefits of the good. Some examples of these are listed here: cable TVs, private parks, cinemas, etc. A cable TV, for example, it requires a monthly fee but is non-rival after that payment. And then finally, we have public goods. Public goods are goods which are both non-excludable as well as non-rival. Information and knowledge are common examples of public goods. The other type of examples include air that we breathe, public parks, street lamps, etc. However, the biggest problem with public goods is known as the free rider problem. The characteristics of the public goods determine that they are easily to be consumed without payment. This nature of information as a public good is crucial to how we understand the economics of intellectual property. The public good nature means that there is no loss in quality or quantity when information is used or transferred. Therefore, information is most efficiently used when it is freely and widely consumed. In other words, when we put artificial legal sanctions or legal rights such as intellectual property over information goods, we are actually creating an inefficiency, since information is a public good, which means it is most efficiently used if it is given out for free and widely consumed. George Bernard Shaw actually came up with a quote which quite aptly describes the public goods nature of information. The quote is, he starts, "If you have an apple and I have an apple and we exchange these apples, then you and I will still each have only one apple. But if you have an idea and I have an idea and we exchange these ideas, then each of us has two ideas." Let's move on to slide 7, which discusses the incentive theory. The incentive theory starts from the point that information goods are most efficiently used when they are freely and widely consumed. However, it questions that if it is freely and widely consumed, how does the creator of such information goods, or someone who comes up with an idea that helps mankind, for instance, how does such a person recuperate the investments made in creating such an information good? Especially when the idea is easy to copy or easy to reverse engineer and reconstruct. Since the difficult part, that is coming up with the idea or coming up with methods which can implement the idea, has already been put out in the public, anyone else can just copy this and reconstruct it. Therefore, there is very little incentive for the creation of new information. Once the information is created, the ease with which it can be reproduced or reverse engineered proportionately reduces the ability of the creator to recuperate any investments that he or she may have made in the creation of such information. Therefore, in order to create incentives, artificial legal restrictions are implemented. These are intellectual property rights. When this limited right to exclude others from reproducing that information, either in the form of a patent or copyright, for example, the creator or innovator is able to appropriate benefits during that period by monetizing the creation through sales or licensing. This exclusion right therefore acts as an incentive which increases the rate of information. However, as described earlier, information goods, since they have the public goods characteristics, there is an inefficiency created when this exclusion right is granted, since it is no longer being most efficiently used. This initial inefficiency that is created by allowing intellectual property rights and reducing the spread of information is known as a static inefficiency. As the ability to exclude other competitors from the market allows creators to charge a price above the marginal cost, that is, it allows the innovator or the creator to raise the price than they would have in an otherwise free market, it leads to certain consumers who would have bought it at that lower price to now be priced out. Since a lesser number of people are able to make use of the good, this is another inefficiency that is created. This loss is referred to as a deadweight loss. Similarly, other costs that arise include transaction costs, administration costs, and enforcement costs of these intellectual property rights. So together, there is a significant amount of inefficiencies created by allowing these intellectual property rights. So the question now arises, why do we allow them? The static inefficiencies, that is all these inefficiencies I just described, act as an incentive to increase the overall rate of innovation. That is to say, unless they were present, creators or innovators would not be incentivized into coming up with that good in the first place. Thus, the static inefficiency is seen necessary for what is known as dynamic efficiency. A balanced IP regime therefore needs to ensure that the losses from static inefficiencies are much lesser than the gains from dynamic efficiency. Therefore, analysis through this incentive theory lens focuses on the trade-off between static inefficiencies and dynamic efficiency. Or more specifically, it tries to ensure that the dynamic efficiency is greater than the losses from static inefficiency. To give a simplistic example, if the patent duration over any invention was raised to 100 years of a patent monopoly, this would mean that once you create something and patent it, for the next 100 years, you would be able to charge whatever price you want, since no one else would be allowed to copy your patented invention. However, a patent duration of 100 years would mean 100 years of monopoly pricing. This means a great number of people who would have otherwise been able to buy that good at a free market price is now not able to buy that good at this new monopoly pricing. This also means the information is being underused and underutilized. So this static inefficiency is huge. In order to justify such a static inefficiency, you would need to prove that this static inefficiency is required, is necessary to bring the rate of innovation that you desire. If it cannot be proved, there is no reason to have this big a patent period. The same trade-off exists in copyright law. So while patent law is more or less fixed at 20 years across the world now, there is talk of copyright periods being extended in certain countries. In that case, the incentive theory, as described above, would be the kind of consideration policymakers would need to consider. Other types of considerations where the incentive theory comes into play is, say, for example, price discrimination, which is seen as one method of reducing static inefficiencies without having to change the current patent laws as they exist. Price discrimination would allow companies to sell certain products at higher prices in developed countries and lower prices in developing countries. This would mean that more people in developing countries would be able to afford this, while they would still be able to make the profit of developed countries, thereby reducing inefficiencies, static inefficiencies, by allowing more access to more people, and also by increasing the usage of information. Theoretically, perfect price discrimination would allow every consumer to tailor the price to his or her ability to pay. However, this is not possible, of course, in real life. It's not even possible to discover what price people would be willing to pay optimally. A more realistic example would be national price discrimination, as I just described, where, for example, a product could be sold at $100 in a rich country and the same product made available at $15 in a poorer country. Let's move on to slide number 9, the critiques of the incentive theory. So, the first major critique which is pointed out is that it only accounts for financial incentives in determining intellectual property policy. It does not include, for instance, other incentives such as prestige or scientific curiosity or lead time advantages in the market. These are all different types of incentives which also push people into making new innovations, into bringing the innovations into the market. And in several fields, including academic publishing, art, software, it can be argued that these incentives are in themselves sufficient to generate innovative activity. There are, of course, other fields, the most prominent example being pharmaceuticals, where non-financial incentives play little to no role, since there's so much money involved simply in coming up and creating that new good. Therefore, from a policy perspective, it would make sense to look into what kind of incentives actually push innovative activity in those specific areas. Therefore, for example, while software patents exist in many countries, softwares rarely have a lifetime of more than, say, 5 years. Therefore, giving a monopoly period of 20 years of patent protection over a software is unnecessarily generating static inefficiencies without generating any dynamic efficiency. If you look into different sectors of technology, it becomes clear that there are different time periods or different breadths of intellectual property which may be more suitable. However, as it currently stands, because of the WTO TRIPS agreement, minimum periods for copyrights and patents are harmonized across the world. However, the same cost-benefit analysis through the incentive theory can be used to justify or to turn down other methods of either strengthening or weakening the IP system or IP regimes as required. As is obvious from this discussion so far, there's also a need to shift away from harmonization across sectors as well as across nations. This will allow nations to calibrate IP regimes to best suit their own individual growth and goals. And finally, the third related criticism is that this incentive theory does not necessitate taking into account distributional concerns. An example of the type of problem that this could create is, take pharmaceutical patents for example. Such a system would equally incentivize the investment of innovative resources into the creation of hair loss remedies as it would into the investment of, say, heart disease. And if it so happens that buyers for hair loss remedies are more willing to pay and more willing and have more money to spend on hair loss remedies than heart disease patients, then this system would incentivize the allocation of inventive resources more into hair loss remedies than heart disease. This is the distributional concern. So with this, we see that there are three main critiques of the incentive theory. That is, it does not take into account non-monetary incentives, it has to go against the trend of harmonization, and it does not take into account distributional concerns. Now we move on to the next slide, slide number 10. This is the next theory, that is private property rights determining patterns of productivity. So far, the discussion has focused on intellectual property rights over information goods. However, there are also other incentive mechanisms, as earlier mentioned, which enhance the rate of innovation over information goods. These include, say, prize mechanisms or government procurement methods, as well as common-based methods, which incidentally do not necessarily share the same static inefficiencies that are present in the IP system. In prize systems, an organization, usually the government or a philanthropic organization, offers a financial reward to anyone who creates a certain invention. Though the prize is usually predetermined, there are instances where it's been announced after the invention has come to light as well. However, if it's announced after the invention has come to light, it is usually more difficult to say that this acts as an incentive for that invention to come about. Prize systems are slowly generating renewed interest in information economics today. And of course, this is not unrelated to the growing criticism that the patent system is receiving. More basic research takes place under grants from the government or philanthropic funds, where rather than proprietary rules such as intellectual property, results are shared under norms of open scientific exchange. Similarly, the commons-based approach to creation can be characterized as a production that is based on collaborative approaches rather than proprietary approaches. A good example is that of Wikipedia, where anyone can make or edit an entry, and then this is then peer-reviewed by other volunteers. Similarly is the open source movement, which has been particularly successful in the field of software. So the question now arises that if these other systems may not have the same level of static inefficiencies that are present in the IP system, why do we look at the IP system? To answer this, we have to look at the question from another angle. As the intellectual property regime relies on a marketplace to give out signals, that is market signals, which are then translated by innovative firms or creators or whoever it is making the inventions. They use this information that the market gives them to determine where they want to allocate their inventive resources. Thus, the decentralized system, that is the IP system, it helps direct innovative resources towards maximizing social welfare. We say maximizing social welfare as there is an assumption that consumer demand would determine successes and failures in the market, and by extension, goods that met the most social value, that is, goods that people are most willing to pay for, would be indicated through market signals, and thus market signals would indicate which goods are valued the most on the market. In contrast, for example, in a price system, the price setters would be tasked with determining how and where their prize fund could maximize social utility, and the cost of generating such information is extremely high, because generating the amount of data required to come to a conclusion as to what type of good or what type of innovation is most valued or will have the most value is extremely expensive to undertake. Since market signals don't rely on any single entity or any centralized body to generate this information, but rather are in fact signals expressed by the public and hence decentralized, it has been theorized that the efficiency gains in collecting information regarding where innovative resources should be allocated automatically make the IP system more efficient than other type of innovations, despite deadweight losses and other static inefficiencies that may occur with the IP system. Now, this premise has taken a central role in much of the subsequent economic analysis of intellectual property, since this analysis has led to most scholars focusing on trade-offs internal to intellectual property, rather than focusing on IP as one of several different methods of innovation. That is, they look back to the incentive theory to determine what kind of trade-offs internal to the intellectual property system, such as patentability, breadth of a patent, standards of novelty and non-obviousness, patent enforcement, etc. There are also questions of restrictions or limitations to intellectual property, which are often debated in terms of transaction costs, such as preventing the abuse of patent rights, or flexibilities, such as compulsory licenses, fair use and copyrights, etc., as the transaction costs involved in the ordinary execution of such exchanges would be too high to allow the information goods to reach the hands of the people who are able and willing to pay for this. However, this assumption that property rights, such as intellectual property rights, will necessarily indicate the best direction for allocation of inventive resources is not necessarily correct. It's useful to look at the differences between physical property rights and intangible or intellectual property rights, which may help to understand why this false assumption may occur. In the case of physical goods, property rights are often seen as the best method of ensuring that physical objects, or land as the case may be, is best made use of, as it is commonly understood that private ownership incentivizes owners to make best use of that property rather than if it were held in the commons, that is, preventing the tragedy of the commons. On the other hand, as the economics of information makes clear, So-called property rights over intangible property are given despite the fact that most efficient use of that information or knowledge is when it is available to the public. Therefore, it does not necessarily flow that owners of IPRs will make best use of the information goods. Neglecting this distinction often undermines the importance of the public goods nature of information. It also thus undermines the importance of the public domain. If the trade-off isn't properly calibrated, there is a danger of allowing deadweight losses to overshadow any dynamic efficiency-based gains. The paradox thus remains. If IP is made stronger than required, you will get clear market signals as to what type of activities are most desired, or rather that people are most willing to pay for. However, granting overly strong IP rights would lead to over-investment in certain market-centric types of products. However, it's not necessarily true that the best use of intangible information is necessarily in market-centric types of products in the first place. Therefore, it is not very clear that market signals will indicate at all whether information or innovative resources should be directed towards goods or towards causes which do not necessarily make an impact on the market, or not directly on the market, such as education, primary research, health of the poor, etc. Moving on to slide number 14. The third major theory, or rather approach, looks into racing issues, or non-coordinate issues, also known as reducing duplication issues. This category looks to reduce economic wastage that can occur in the inventive process through IPRs, and has broadly led to a re-examination of IP as one of the at least three methods of innovation, rather than as a sole determinant of innovative activity. Although questions internal to the IP regimes are still most predominantly discussed in the IP innovation framework, due to, as previously discussed, the patterns of productivity of private property, it is worth noting that there is a small but growing dissent to the premise that IP is a more efficient system than other innovation systems. Looking at the issue of racing, that is, when multiple firms separately expend resources working towards the same goal, two innovation systems, that is the IP system and price systems, could result in a lot of duplicative and wasteful investment, as eventually only one entity will secure the incentive at the end. With regard to racing, government procurement may be more efficient, as this process limits the number of entrants and thus reduces the potential costs of duplicative research. Although it is true that since separate firms undertake the risk of entering into the race for securing the incentive at the end in IP systems and price systems, this overall duplicity which results is often a waste of resources. The other side of this coin is that IP systems and price systems both allow entrants to self-select whether they are suited for that innovative activity. Since entrants are themselves better placed to make use of private information to decide whether they are well suited to competitively invest in allocating their inventive resources towards this incentive goal. If they cannot competitively invest their resources towards this goal, then there are various other types of inefficiencies that can arise, as a financial incentive is awarded or promised upfront and not based on the result. For example, this could lead to delays or low quality work. At the same time, government contracts and price systems face a significant problem. The fund allocator must determine the value of an innovation as well as amongst which innovators the fund must be spread over. If the amount is too small, it won't attract enough entrants. If the amount is too large, it will be wasteful. If too much of the amount is given to the first innovator, there will be very little incentive to improve upon the product. If the amount is spread amongst too many follow-up participants, there won't be sufficient incentive for the primary innovation. However, recent work on price systems have tinkered with models which do not require the amount to be decided prior to the innovation, but rather after the innovation occurs. These methods could include through the pegging of price allocation based on sales, on perceived value, etc. Thus, with the activity in the information economics space being imported into the economic analysis of IP, there's a slow resurgence of looking at IP as a means to innovation rather than as a goal in itself, placing it in the context of several external factors which affect how normative policy could be affected. Moving on to the conclusion. Slide number 15. To recap so far, the economic analysis of IP is concerned primarily with the utilitarian justification for IP, which states that it is for the greatest good for the greatest number of people. There are three main methods that we use in the IP system. That is the incentive method, which balances incentives with inefficiencies so as to achieve an optimal rate of innovation. Secondly, the diminishing distortions in how markets display consumer needs so as to appropriately direct inventive resources to the most optimal usage in the presence of IP rights. And thirdly, minimizing rent dissipation caused by duplicative research. There are at least three broad conclusions that can be drawn looking at this thus far. Firstly, that it is not clear that higher or stronger levels of IP lead to higher rates of innovation. As discussed earlier, it is possible that the inefficiencies start outweighing the dynamic efficiencies if IP is made too strong. At the same time, if it is made too weak, there will not be dynamic efficiency to start with. Secondly, countries of different socio-economic statuses should approach IP in ways that are appropriate to their domestic capabilities. And thirdly, IP should be kept within the pot of larger socio-economic issues. And with this, we conclude our chapter on the economics of IP.